All right, it's setting up now. Great. All right, officer, my first matter, please.
Your Honor, our first matter is 748.
All right, thank you very much. And this is Gateway Financial Solutions versus Crystal Mitchell. Looks like 21160748. Will the parties please place your appearance on the record?
Yes, good morning, Your Honor. May it please the court, Scott Schisler, P48832 on behalf of the plaintiff.
All right, Mr. Schisler. Is Crystal Mitchell here by chance? All right, so
She didn't sign in, Your Honor.
thank you, sir. She was scheduled to be here at 10 a.m. Mr. Schisler, let me just go over the register of actions for your matter. I know it is, we have a motion for reconsideration. There appears to have been summons and complaint 7/1/2021. Change glasses here. Read better. And there was a second summons granted, is extended the second summons to 11:30, but there was personal service on 11/26. And on 12/1, there was a default file. The default was reviewed and entered. And soon thereafter, there was on 1/26/22, there was a request for a judgment by default, and that was dismissed, indicating that the court did not have the notice of a default that was sent to the defendant by the plaintiff, nor proof of service of that. I just want to double check that because I'm looking at the ROA. I'm going to find the order here just to be clear. I just saw it, so I reviewed your case. Okay. Oh no, this was dismissed. See, that's not correct. Glad I looked this up. This is checked off: claim, statement of claim, cause of action and elements, vehicle contract, no information regarding a repossession. So let me look at your, we have a petition to set aside the dismissal and reinstate the case. I'm not seeing, I wrote down motion for reconsideration because I think that was what I thought this was, but as I'm looking, sir, this is a petition to set aside a dismissal and reinstate. It is not a motion for reconsideration. Is that right?
So Your Honor, I guess I'm looking at the notes from my staff, and that might help us.
I just need to know if what you sent was a petition to set aside a dismissal and reinstate the case.
It was.
Okay,
yes.
Okay.
Yes.
So that being,
go ahead.
That being said, I'm looking at this and it says that the petition of court to set aside dismissal for no information regarding repossession and vehicle contract for the following reasons. Judge Adams cited affidavit of claim lacking information regarding repossession. No repossession was completed. So what I'm looking at here is you got your complaint. So once everything has been taken care of procedurally, and I assume there was, because there's no need for me to look at your complaint and your request for your complaint and your default judgment until the court notes that you have submitted the notice of default and the proof of service. So I go to, after the procedural aspects have been taken care of, I go to your complaint. When I went to your complaint, 7 paragraphs, indicating paragraph 5, 8/31/2020, parties entered into a retail installment contract, a copy of which is attached. Paragraph 6, defendant defaulted pursuant to terms of this contract by failing to make installment payments when due, resulting in acceleration of the principal balance. And paragraph 7, defendant owes plaintiff the sum of $14,158.62. So I looked to your contract And I note that this is a contract for a car loan. Would that be correct?
That's correct.
And with these car loans, I mean, there's really, your complaint really, it just says there's a default of the contract. Doesn't say when, but it just says there's a default on the contract. And so when I'm looking at your contract, I'm seeing that you're saying there's a breach of contract, but I'm also looking at this Article 9 matter, because this is a secure transaction. It's an auto loan. And so to get damages for auto loans, there's certain criteria that have to be met, and that has not been addressed at all in your complaint. That's why the case was dismissed.
I guess, Your Honor, in this particular case, this person got in a motor vehicle accident, had no insurance. It's just a simple contract they didn't pay. There is no repossession. There is nothing else. I mean,
but that wasn't mentioned. It's still there. Once it is a certain type of case, when I look at the contract, I see it is a auto loan contract. I'm looking for, there may not be repossession, but that was not, that wasn't mentioned. Excuse me, while I go over here and look at my notes for Article 9 matters, case law as well. So this is, it didn't say one way or another, so I did not know. It just said there was a default. So I need to make a determination with some kind of reasonable certainty, and I could not be certain because it was not addressed at all. So I'm looking for that to be taken care of. If it's no repossession, tell me it's no repossession, and I'll start looking at it as just the regular contract, and that's fine. That's fine. If you can list that in your complaint from now on, then I'll know.
okay.
Now that you have informed the court there's no repossession here, the default happened when?
So, Your Honor, I filed an affidavit of claim, and in that affidavit of claim, the defendant entered the retail installment contract and then stopped paying the default. I'm sorry, I'm looking at it.
This was
It does not. Yeah, it does not tell when she stopped paying in the affidavit claim.
Okay.
In the journal entry.
Well, can you tell me when was, again, this is something that I'm looking at. If you say there's a default, it'd be good if you told me when the default happened. And then we can, that way, we can, so I know there's an acceleration clause in the contract, but that way we get to know, okay, well, how much is due? Because
correct.
Maybe, depending on the timing of the default.
Yeah, Your Honor, in this particular case, one payment was made on October 2nd, 2020, and then no payments were made.
Okay. All right. Those things help a great deal if you, when it comes down to you getting a default judgment. So yeah, I wrote down there's a vehicle contract, no information regarding repossession. Also, like I said, there was nothing that said when the default occurred, when the acceleration occurred. Now that we have this, I'm hoping that you can include this in your future cases, so I won't have to have you come here. That's more time you have to spend on a default case. So whenever I have a question about, usually, well, if I don't have the information, you make a request, the petitioner makes a request. If I don't see what is required for that request, I'm going to deny it. And there's nothing else for me to do with your case but dismiss it, since I denied the motion. So I will set aside the dismissal based upon what you have informed the court of as of this time, reinstate the case, and consider your default judgment.
So, Your Honor, why don't I do this? I will file a new affidavit of claim that details all of those issues of the default and the fact that it was not repossessed.
You don't have to do anything else for this matter.
Okay.
I'm hoping you do this before when you request your default judgment, so I just won't have to have you come back.
Yeah, I normally do, but.
Yeah, but for this particular case right now, as I said, I'm going to grant your motion which is to set aside the dismissal. I will reinstate the case. Now, let me see, let me just double check to see if the default was ever sent. The notice of default and the proof of service of that. I'm not seeing, well, the proof of service says, proof sent. I think I saw that, 12/16/21, it says proof filed default entry.
Yes,
But
so Your
but
Honor,
I don't see that.
so, so there's an affidavit of claim that I filed that had exhibits attached to that. And that would have been probably, I have it signed as of 12/13, so I would think 12/16 would be about the right time for that to be filed. It is Exhibit C to that affidavit of claim, which is the proof affidavit of mailing.
This affidavit of claim I have has a court time stamp of March 2nd.
And that would be the second one. If you could look back, there was an original one filed back in December.
Is it on your register of actions?
Looking.
'Cause I don't see one. I'm looking. Maybe it's here. Let me look.
Oh, so
Here it is. Here it is. Here's an affidavit of claim with the default judgment request.
correct.
And it is acknowledged and sworn and subscribed January 28, 22.
And Exhibit C of that is a proof affidavit of mailing that says that the default was mailed to the defendant on 12/13/21.
Yeah, got it. And yeah, I must have saw this because otherwise I would have dismissed it based upon the procedural aspects.
Correct.
But I went to the contract, so that's fine. So let me just put on here, grant, the order is to grant motion to set aside dismissal. And reinstate case. And we will enter default judgment. I'll have to type all that up for you so you can get that in the mail very soon. Let me sign off on the default form. Strike that $14,443.62. Today is the 7th of April. Is there anything else with this matter, sir?
No, thank you, Your Honor.
Thank you very much. Now, what's your next matter? Last
My
two
ne-
minutes?
495.
Thank you. And this is Gateway Financial Solutions versus Sammy Darrell Williams, 211-63495. Will the parties please place your appearance on the record?
Yes, good morning, Your Honor. May it please the court, Scott Schisler, P48832 on behalf of Gateway Financial Solutions.
Is Sammy Williams here? No? All right then. Officer Sammy Williams is not signed in.
Has not signed in, Your Honor.
All right. There's one defendant here. I have summons and complaint file 8/13/21. There was personal service, looks like twice as far as the register of actions is concerned, on 9/1 and 9/7. On 9/27, there was a request for a default. The default was entered on 11/16/21. And then there was a brief in support of a default judgment, 1122. And it says default denied, but I think that would be for default judgment. Well, let me look at this because, like I say, I have a default entered 1116. I have a default denied 1122, just like I have two services. So then I have a default judgment denied. So let me find those documents in the file. So we'll have some clarity on this. All right. This went back last year where we were trying to have hearings on the matter. You have default entry for Sammy Darrell Williams dated 11/16/21 as indicated. I think at that particular point, there was some confusion in this matter. So let me see what we have here for 11/22. Okay, and the 11/22 matter, that should have been default judgment denied. Not default denied, default judgment. I do have that order here, and it indicates that no notice was given. The same notice of default entry and the proof of service for that. But I do have on the soon thereafter, I guess you filed another affidavit of claim, sir.
We did.
Yeah, I have here the proof of service or affidavit of mailing. It is dated 12/7/2021, indicating that at that point, you did send the notice of default by first class mail. This is your proof of service. So we do have that. So the procedural aspect for that is taken care of. I just will take that as a second request for a default since it was done after the first request.
I believe the first request also, Your Honor, did not have the notice of repossession. That's what the note that I have says. So in the second affidavit of claim, we made sure to attach the
It's terrible.
notice of repossession.
Then they want to give you, I
Excuse
just don't
me,
want my
please
license
mute
to be
yourself.
suspended behind it. And that- You can't even get in.
Sorry about that, sir.
Oh,
I
no
don't
problem.
have that listed on the first for the default denial 11/22.
Okay.
All I have was, let me go back to that.
No proof of service?
No notice, yeah, no notice. That's what I have. I don't have anything else marked off. Just there was no notice of the default sent to the defendant by the plaintiff. So
Okay.
I don't even have that.
Okay. Like I say, it's just a note in my file, so I don't
Yeah.
know where it came from. So.
Okay, so apparently with your affidavit of claim, that's when I'll take that as somewhat of a second request for default judgment. And that was denied on 2/10/22. Let me find that.
And that may be what the note is actually referring to, Judge.
Yeah. Just trying to find it in the file here. Just please be patient with me as I try to locate it. These files get thick, a lot of documents.
Detroit.
Please mute yourself. Now, while I'm looking for that, I will have anybody who has signed in, if you can, I mean, anyone who has come aboard or come on our Zoom proceeding at this time, please check in with my officer. So we're just going to take a little short recess, council, while I look up the document that we were referring to.
Yes.
Do I have anyone that has not signed in? Need to sign in now with me. I need the last three numbers of the case number, please.
My name is Nashawn Combs, and I don't have the case number. Hello,
Yes. You need to say your first and last name again?
Nashawn Williams Combs, and I've been trying to get in for the last hour.
Yeah, I don't have you. I don't have you on my docket. This is a civil courtroom. This is courtroom with Judge Lydia Nance Adams, courtroom 534.
Okay,
Hello?
how do I get to the Zoom that I'm trying to get to?
Okay, I don't know exactly which one that you're trying to get to, because you don't have a case number or anything. You know what kind of case it is?
It's a traffic ticket. I have the Zoom ID.
If you have the Zoom ID, it should have the courtroom also.
I just have the number they gave me.
Okay, because this is courtroom 534. It should have the Zoom ID with the courtroom number.
It don't.
Just like you sign in there here with the medium ID.
60337.
Also, you're probably in like maybe 220. I'm just guessing.
Okay, can you connect me to that one, or how do I get there?
No, basically you have to do it the same way you sign in here. But instead of using 534, you can try 220. If not, they can actually find the exact one you're in.
Okay, all right,
Okay.
thank you.
You're welcome. Do I have anyone else that need to sign in? Sign in. I need the last three numbers of the case number.
How you doing? I'm here on, there's 6 motions to reinstate. They're all LVNV funding. I can give you the case numbers on each one.
Okay, and it look like all the ones I have. My 1030 is all you, right? Look like I have about
6 of them.
them. They all yours, right?
Yes.
Yeah. Okay, so you good, counsel. I got you
Perfect.
all signed in. Okay, I see. I have 2 people here, but no one signed in with me yet. I see one say Iris David.
Yes, I'm right here. I had my phone on mute. I didn't realize it's
Okay,
not.
no problem. Could I get the
Case
last two
number
numbers of
is
the case number?
402, but I just had a question before we proceeded. I did a credit card cancellation, and they're supposed to be doing this for me. So I don't know if I have to stay in, or how do I go about it?
Yes, it probably 9 times 10 it'd be best you stay in, and what you can do is you can probably once your case is called, you can ask the judge, could you go in a meeting room with the attorney?
I'm appearing on behalf of that one. Is it possible to go in a breakout room? Because this one.
Yes,
is
what you
resolved.
can do is, counsel, when that case is called, ask the judge, because you're in the defendant going in the breakout room.
Okay, yeah, because it would just be
Yeah,
quick.
I don't have that power to put you in a breakout room. Only the judge had that power.
Got it. Okay, perfect. Just Ms. David, it looks, just as a quick, we're going to withdraw the motion because it looks like it's been paid. We just didn't receive one of the documents back, but we're just going to withdraw it, and everything it's been paid.
Okay, so do I stay in
I
court?
would,
or
yes,
can
I
I leave?
would stay on here until the judge calls.
Okay, thank you.
Okay, I have someone else in my corner screen. Do you need this to check into my court also? Hello?
Are you talking to me, Iris?
No, it's not you. It's
Oh, okay,
somebody
I'm
in
sorry.
a blue shirt.
Okay, no, that's not me.
They probably you think so? There
Hello?
you go. I can hear you now. I
Yeah,
can hear
this
you
is-
now.
Yeah, my name is Gerardo Mendez Roman Jr.
Okay, do you have the last 3 numbers of case number?
Yeah, 40000.
400. Do you know that on my docket? Well, what type of case is it, sir?
This is let me see if I can, because I was supposed to have the last score today, and I try to get into soon, but I have problem with my phone until now.
So this is a civil courtroom. What type of case do you have, sir?
Okay, where do I can find that?
No, I'm asking you. What type of case is this?
Ticket or?
Is it a ticket?
No.
What type of case is it?
This is it's from credit union. I mean, not credit union. Genesis Credit. Yeah, Genesis Credit Union.
Do we have a judge name on your paperwork?
Yeah.
What's the judge's name?
I got it right here. I got the paper in my hand.
Yep. Yeah. Well, what's the judge's name on the paperwork?
Okay, what's the name of the judge? What's the name of the judge?
I tell you what. Do you see the case number?
Yeah, case number is 21151415.
Okay, stand by, please.
All right. We're back on.
Sorry, hello,
Excuse me,
hello.
Ma'am.
excuse me, please be
My
quiet.
audio just got cut
Hello?
off.
Okay, so
All right, so
Stand
I
by, ma'am.
understand that you're checking people in, officer. We'll get to that momentarily. I'm gonna ask that Madam Clerk, we look into how we can, take care of all these people joining on our Zoom proceedings, interrupting our proceedings. We gotta get this worked out. There's something's not right. So, you know, let's see what we can do with that, okay?
Want me to zoom in?
Huh? No, you don't have to zoom in. I'm just saying we need to call second floor, whoever the clerk is, you know, we need to see what they're sending. And why come we keep getting people signing into our courtroom, interrupting our proceedings? They're not even civil cases, you know, traffic tickets. And if I call, it's gonna be a big to-do. And I don't want to call and make a big to-do. I just want them to figure this out so they can put the right number on whatever notice they're sending out to these folks. So work your magic is all I'm saying, Madam Clerk. See what you can do and what you can find out. And if it comes to a standstill where we can't do anything, let me know. Then I will, you know, I'll get involved. But this makes no sense. It makes no sense.
I don't know about traffic, how they get in our courtroom.
yeah, we get that every day, y'all.
Yeah, we get every day. So they must be sending them notice. I know Adams is probably at the top list and that's what people call, but we just need to make sure that they're not putting, you know, our Zoom ID number on anything. I'm not sure if that's happening or if people are just like, they get a list. I don't know. So yeah. Just do what you can and then let me know, follow up with me, let me know what's happening with that.
Okay, but Mr. Romero, his case is closed. It was a consent judgment signed on March 22nd.
Okay, I don't know who that is.
No,
Let me deal with that. What's the last 3 numbers?
We don't have his case today.
Oh.
His case,
Okay, well,
It's been dismissed.
yeah, his case is, it was originally scheduled for today, but because of he signed a consent judgment, and I entered it, it's closed out. It closed it out and took the hearing off the document. So you're free to go. Roman.
Mr. Roman, you hear that? You're free to go.
So I didn't have to stay in the court.
Nope, you're free to go, sir.
Okay, thank you.
Mr. Roman,
Yes, ma'am.
did you hear what she said, sir?
She said the case is closed and I signed a consent with them.
Did you?
Yeah, I received a letter from you, sign it, and then
That's all you need to know. So the matter is closed out. You just seemed like you were concerned after she said what she said. So the matter's closed out. You signed a consent. Make sure you comply with the consent and have a good day.
thank you very much, Your Honor.
Thank you. Now, officer, did you get finished checking people in? Because I have Mr. Schizler to take care of and
Yeah, I just got one person that popped in and, ma'am, I don't see a name or anything, but you on our Zoom. Do you have the last three numbers of your case number, ma'am?
Yes,
What's the last three number, ma'am?
0000.
Boy. Okay, you're not on our docket. What's your first and last name?
Anita Flowers.
and what
Okay, ma'am.
what Zoom meeting ID do you have?
Zooming. 360-534-0000.
That's what that's your Zoom ID number. That is not your case number. It's your Zoom ID.
Oh, I'm
Okay.
sorry.
And
Your
so,
Honor,
okay,
Your Honor.
just let me interrupt. And from that, we know that they're giving them the wrong, okay? They're giving them the wrong ID number. So,
Your Honor, if I may, she's appearing on the last three is 931.
okay, so it is 931 because she says 000. Okay, so she is with us. Okay, very good. Now, anybody else you need to check in, officer?
Look, that's all we have on, look like we all set to go, Your Honor.
Thank you very much.
And
Let me
the
get back
first
to
matter,
Dave. I'm sorry.
and our first matter is 402.
Well, no, I'm still dealing with Gateway Financial Solutions versus Sammy Darrell Williams. We just took a
Okay, I'm
short
sorry.
recess. 211-634-95. All right, counsel is here. I do have for that second denial of the default judgment, it does say Article 9 repossession requires notice of sale not provided. Okay, I do have that. So that is why, unlike what the Register of Action says that there was no notice sent, that was not the situation. The situation is that it was an Article 9 matter. So let me look. So this must have been an auto sale contract, correct?
It is.
And was there repossession? I know you probably say you have it in your affidavit
Yeah,
of claim. Was it a sale?
there was.
Okay. I see here, it was sold. Did you provide a notice of, go back over here, get my notes, because it's a bunch of things that are required.
Correct.
These matters. So notice of the deficiency sale, that's included in the affidavit?
It is, Your Honor. The affidavit, and I realize we're dealing with two affidavits, and that's because when we got the notice from you, we then amended it and filed it. So there's a affidavit signed February 25th, 2022.
I'm looking at the ones dated January 19th.
Yeah,
Okay,
and
but okay, I see the February 25th, 2022. So there's a notice of deficiency here.
So if you look at Exhibit C, Your Honor, there's the notice of our plan to sell the property and then the notice of deficiency. Those are the two notices that are required.
I see the notice of deficiency balance. Okay, we need notice of the sale.
Yeah, and I have that. It's also part of Exhibit C. So it's my Exhibit C has 2 pages. The first is the notice of the plan to sell property dated April 29th, 2021.
These aren't labeled as Exhibit C and They're just all together. Okay, I do see, as I look through here, notice of plan to sell property is dated 4/29/2021. This does indicate that this will be sold at public sale on 5/17/2021. Okay, so we have that. All right. So this would be though included in your third. What I try to do is give a summary of how it happened and what it happened. I know eventually, we'll get to that, but
Right.
I think it's fair that I tell you, at least from my perspective, what I'm looking at, what actually happened. So yeah, you had this in the third, and for this motion, you have it, but you didn't have that in your first, or did you? You didn't have it in your first motion for default judgment,
So
and you didn't have it for your second request for default judgment. Is that right?
So that is correct. In the first one, Your Honor, and that was back when we were figuring out exactly the process that we were going to use.
Right.
The second one, it was overlooked. It should have been attached. It is normally in there. It just wasn't in there. Yes,
Okay.
correct.
So, but now we have it.
Yep.
I want to say this is a third attempt, but it's really not. It's really a motion to set aside dismissal, reinstate case. And once I reinstate the case, I just want to move it forward. I would not reinstate it if we couldn't move forward. You have your request for the default. Before I do that, what is the date of the default?
Of when the person actually, we're not talking about the entry of the default with the court. You're talking about the default with when did the person
When they did
sign?
default the contract.
When did they default on the contract? Here, real quick. Your Honor, the last payment was made. I'm sorry. I'm looking at the balance ledger here, and I want to make sure I have it right. So the last payment, Your Honor, was made April 9th of 2021.
The allegation payment. I also have a payment 4/26.
4/26. That is correct.
Okay.
Yes, and that posted late. They were already in default at that point in time, and that didn't cure it, but it did come in.
Okay. All right. So now that we've had all of that on the record, the court will submit an order to grant the motion to set aside dismissal. Yeah, if you can include those things inside your complaint, that would help. We will reinstate case and grant default judgment. Let me go to your form that you submitted to the court so I can sign off on that. Or did you send another one? We have the default. Okay, $5,815.16 for the default judgment.
That's correct.
Right, got it. Okay, I think that takes care of everything, sir. How about with yourself?
That's all set. Thank you,
All
Your Honor.
right.
Appreciate
Well, thank you for your time. I appreciate it.
Yep. Have a good day.
You too. Next matter, officer. Did I say I got a 10:30 docket? It's past that time. So what's the
Yes,
next matter?
start about 10:30 docket, Your Honor. Our first matter on our docket is 402.
Okay, 402. Good morning. This is LVNV Funding LLC versus Iris David, 2116-1402. Will the parties please place your appearance on the record?
It's Craig Fay on behalf of plaintiff LVNV Funding P81401.
I have Preston Nate as the attorney of record. You're standing in on his behalf?
Same firm, but yes.
Okay, very good. And in this particular matter, is the defendant here?
Yes, Iris David.
All right, thank you very much. So we have a motion to reinstate. That's what, reinstate the case. It looks like, looking at the register of actions, there was personal service of the summons and complaint 7/23. And then in November, there was a notice of intent to dismiss, and it was dismissed for lack of progress. And in February of this year, we received this motion to reinstate the case. That would be correct?
That is a correct timeline, but at this time, we were requesting to withdraw. There was a settlement in place. We just hadn't received the settlement documents back, but since the filing, we have received payments to close out the account. So at this time, we're requesting to withdraw that motion.
All right, so the matter will continue to be dismissed from plaintiff. Withdraw from plaintiff. All right then, is there anything else at this time?
Not from plaintiff.
Do I have to worry about anything else, or am I fine?
Matter is dismissed as far as the court is concerned.
Okay, thank you.
Thank you, good luck.
You too.
All right, next matter.
Our next matter, Your Honor, is 179.
Thank you. This is LVNV Funding LLC versus Julian Hardiman, 21160179. Will the parties please place your appearance on the record?
This is Craig Fay on behalf of Plaintiff LVNV Funding, P81401.
All right, and is the defendant here at all? Julian Hardiman?
That's negative, Your Honor.
Officer, he's not signed in? All right. I'm sorry?
I'm not signed in, Your Honor.
All right, very good. So in this particular matter, again, there was personal service on 7/26. It was timely. There was a notice of intent to dismiss issued on 11/24/21. And then on January 13th, 22, the matter was dismissed for lack of progress. There was a motion to reinstate filed. And the motion to reinstate because the dismissal was for lack of progress. Let me double check. Lack of progress. Dismiss. 1 second. Two 2.502. Motion for good cause. Motion with good cause. Okay. So we have that here. Did you want to address that? You're just saying that there was service, but there was no action. So I'm trying to see what's the good cause for there not being any activity on this matter, even with a notice of intent to dismiss.
Sure. Yeah, thank you. If you see, look to Exhibit B, we did send a copy of the default entry and judgment to the court October 15th. There is a proof of, I say proof of service of taxation cost that we served on the defendant. And at the same time, that's when we mailed a copy of the judgment as well to the court. I know that we did check the register action. It doesn't look like the court received it, but we did take the action to submit a default judgment to the court for review and signature.
Okay, so the notice of intent to dismiss went out 11/24. Then 1/3/13, that's when the dismissal took place. I don't have any activity until 1/24 with the motion to reinstate filed by the plaintiff. You're indicating to the court that, let me see, your motion says defendant was served. Okay, we got that. There's no issue there. On this October 15th, just like you said, our office mailed the default request, entry, and judgment to the court for filing, along with the proof of service of the taxation of costs. So the Exhibit B got the proof of service for the taxation of costs. This is subscribed and sworn October 21 of 15. The letter, though, is dated August 30th, 21.
Correct. It looks like the judgment was processed prior to, but then it wasn't sent out until the 15th of October.
The judgment was, I don't understand, what was, did you just say the judgment went through, or?
Yeah, it looks like the judgment, it looks like it was processed, the date that on the letter, the August 30th.
The
but it
request
was-
for a judgment, right? Because there is no
Correct.
judgment here.
Correct, yes, request for judgment. But it wasn't mailed out until October 15th, the same day that the proof of service for the taxation of costs that was served on the defendant. So they both would have went out on the same day.
Okay, so, what's your process there at the firm? So when you get the notice of intent to dismiss, does anybody look into it then, or?
Well, that's the other issue, because the only way we found out that the case was dismissed is when we checked the ROA. We just have a scanned copy of the online docket. So we don't have a copy of the notice of dismissal, the notice of intent, or the actual dismissal. We just have the online, that we just went on and printed or scanned a copy of the online docket from the Register of Action showing that the matter was dismissed.
So you don't receive them at all? You did not receive the
Yep.
notice of intent?
Correct. We didn't receive either the notice of intent on the file, and I believe this is basically the issue on the remaining 5. We don't have, the only way we were notified the court dismissed the matter is when we followed up to see if a judgment was entered on the Register of Actions. So we don't have a record of receiving the notice of intent or the actual dismissal from the court.
Did anybody call the second floor to try to find out what the situation is? Because if you're not, I'm going to begin a lot of your cases. If you're not receiving the notice of intent to dismiss or the dismissals.
I don't necessarily know the problem. There was a bunch of, I think we may have filed quite a few with 36 in general, just around the same time that we didn't receive the notice of intent. I'm not certain that we're still having that issue, but it was just around that specific time, the October, early November, I believe.
Because these are administrative matters. This is not something I did not, the court or the judge did not dismiss this.
No, I know.
This was a time thing where we didn't get any documents. And so that's something you all need to look into quite a bit. Okay. Because it's going to cause a lot of time you spending on cases where you don't have to. So with the motion to reinstate, that's what you're saying. We have good cause because we actually did send in, but for whatever reason, you all didn't receive it. So that's 2 things that's not happening here. You all are not getting the notice of intent to dismiss and the dismissals once they are issued. And you're telling me that we're not receiving your requests for defaults. I don't have a proof of service. We just have proof of service of when you mailed something else. So both of these are based upon just missing documents. And that is, yeah, that's unfortunate. You're an officer of the court, so I'll take your word for it, but this is suspect. So if we're going to reinstate the case, then I am taking this as you are requesting, and you're going to be allowed to submit a default request.
Right.
We can do that right now to move the case forward. Because if I just open the case, it's just open, subject to, whatever, subject to it possibly being more time that goes by, especially since you're not telling me any of this has been resolved. So I see here that there was personal service by the ROA. Let me look at it here. That was done 7/26. Looks like it was done in a timely fashion. So that's taken care of. So you have what you need for a default. But for the default judgment, we're going to need that military affidavit and the facts to support it. But you have I'll reinstate your case.
Thank you, Your Honor.
From what you indicated, officer of the court, reinstate case. Enter default. And we will send that to you, and you do what you have to do to get it to the defendant, like you
Correct.
would have. So that's what we'll do, reinstate case and enter default. Okay?
Perfect. Thank you.
Thank you. Especially since they haven't even shown up today. Next matter, officer.
Next matter, Your Honor, is 913.
Thank you. And that is LVMV Funding, LLC versus James Mariner, 2116-3913. Will the parties please place your appearance on the record?
It's Craig Fay on behalf of plaintiff LVM Funding, P81401.
Is the defendant here, James Mariner? Officer?
Have not signed in, Your Honor.
Okay, so why am I doing these cases where people haven't signed in first?
Well, we only had that one that the person signed in. All the rest of them, no one signed in.
Oh yeah, but we got a bunch of people here. Okay.
Okay.
Okay, we got at least 2 other people here. A Zoom user and somebody else with just audio.
Man, we have you on Zoom. Could I get the last one on your case number?
Oh, you check her in. Okay.
You might have yourself on mute, because I don't think you can hear me.
Hello?
Hello?
You talking to me?
Yeah,
No, ma'am, you're checked in already. You're here
Oh,
for
sorry.
we already talked. We're talking to
I'm sorry.
another young lady on the phone. It's labeled Zoom user. I'm going to ask her to unmute herself. Ma'am?
Yes.
No, not you. What's your name?
Sorry.
What's your name, ma'am? I will ask you your name.
I need the flowers.
Okay, so Miss
Flowers.
Flowers, we're not speaking with you. I understand you have another matter here, okay? So
Okay.
with counsel, he's
Okay.
already confirmed that. So I'm not speaking to
Okay.
you. I'm talking.
Okay, I'm sorry.
No, that's
I'm
that's
sorry.
okay. It's confusion. I'm talking to the other young lady that is in our Zoom meeting with glasses.
Hello, yes,
Yes. What's your name, ma'am?
Eleanor Bankhead,
And what is the last 3 digits of your case number?
803.
All right.
Okay.
So we got
Thank you, ma'am.
two people here
Right.
that we're going to deal with their cases before we deal with people who are not here. So let me get
Okay.
to this Flowers case, which is
Mhm.
931.
All right.
Okay?
Correct.
Deal with Miss Flowers case.
Okay.
This is LVNV Funding LLC versus Anita D. Flowers, 2116091. Will the parties please place your appearance on the record?
It's Craig Fay on behalf of plaintiff LVMV Funding, P81401.
Madam Defendant, your name for the record, full name?
I need the flowers. I needed these flowers.
All right, very good. So I have you here today because we have this motion to reinstate the case. The case was dismissed for lack of progress on January 13th, 2022. So plaintiff requested that the matter be reinstated, indicating that the default judgment, there was some activity, but apparently the court did not receive it and is not on our register of actions. So that being said, there was, or there is a request, or there's going to be a request for a default. Right now, the matter, as I said, it's closed. Did you all want to have the opportunity to talk regarding this matter? The breakout room, or did you want me to proceed?
If Ms. Flowers wants to discuss, more than happy to.
I don't mind.
All right, I'll put you in a breakout room. We'll just be in a recess for a bit, okay?
Perfect.
Okay.
All right, so you're gonna be, let me get my breakout rooms together. I'm gonna assign you to room 1. And you should be getting your invitation soon, and we'll just wait to see what happens.
Perfect. Thank you.
All right, thank you. All right, so while we wait for them, the lady for 803 is gone. She had been here all that while. Okay. Well, we'll be in a short recess until they get back. Okay. I see you're back, counsel.
Miss Flowers, she's on a phone, so I don't know how.
Okay, I'll try to bring her back. All right. So you all had a chance.
Thank you.
Still have case 21160931. You all had an opportunity to talk in the breakout room.
We did, Your Honor.
Yes.
We did come to a payment plan. If the court would reinstate the case, I indicated to Ms. Flowers that we can sign off on a conditional dismissal whereby Ms. Flowers would pay $20 a month beginning May 7th of this year and continue on the 7th of each month thereafter.
Are you in agreement with that, Ms. Flowers?
Yes, ma'am.
Okay, so I will reinstate the case.
He needed your help. Okay.
And I'm going to schedule a control date for that agreement. Now, typically what happens is the plaintiff will draft up the agreement, send it to you for your signature. You read it over. If you agree with it, you sign it, you send it back, and then they have to send it to the court. So I don't want the case to fall through the cracks with my reinstating it, my opening it back up. So I'm going to give you a control date about 30 days out. And if I have the consent agreement and I sign off on that prior to that date, you don't have to show up because I'll probably close it out again based upon your agreement. However, if but just in case there's any issues, I'll need you to come back on that date just in case. Okay.
Okay.
Okay. So let me see what I'm doing here with my register of actions here. Look on the schedule. So we're looking, today is the 7th. Looking at maybe a control date of the 4th or 5th, but I'm kind of swamped on those days. So let me see what I have here. And again, you don't have to show up. I think I'm gonna do May 5th. At 9:30. So this is pending consent agreement. Okay, 5/5/2022. That's a Thursday, 9:30 a.m. Okay, and Ms. Flowers, if you have any questions as to whether or not the court has signed off on your consent by that date, I would ask that a few days prior to, you check with on the 36th District Court website. You look up what's called a Register of Actions. We call it an ROA for short. That Register of Actions is a summary of your case. And once I sign off on your consent agreement, it will be on the Register of Actions and the case will be closed out. Okay?
Okay.
All right. Well, if that's it with your matter, thank you very much and have a great day.
Bye-bye.
Take care. The next matter I have is.
I just wanted to step in. I just had another attorney from our office, Keith Sparks. He popped in because I have to take off for another hearing.
Oh, okay. No problem. No problem then. I'm just going to call LVNV Funding, LLC versus Eleanor Bankhead, 21163803. Will the parties please place your appearance on the record?
Eleanor Bankhead here.
All right.
Keith Sparks here on behalf of the plaintiff, P77485.
Okay, and I have Mr. Preston Nate as the attorney of record that you're standing in on his behalf, correct?
Same office, Stinger and Singer, Your Honor.
Thank you very much. So for your Register of Actions, I have here that the summons and complaint was filed 8/17/2021, and there was personal service 9/5/2021, which was timely. And then there was a notice of intent to dismiss December 17th, 2021, and the matter was finally dismissed on 1/31/2022. As a result, the court received a motion to reinstate on 3/15/2022. So there has to be good cause in the motion for reinstatement. All I have here is that defendant was served. There's no question there. But I think paragraph 3, on or about November 10, 2021, our office mailed the default request entry and judgment to the court for filing. But we don't have that. It is still not on our register of actions. I spoke with counsel before you. He was not able to tell me whether that was looked into or not, because if it's not, you all are going to be here quite a bit for these matters. And after a while, I don't know if it's good cause anymore, if it continues to occur and it has not been rectified. Not only that, you all not receiving notices of intent to dismiss nor dismissals. We are not receiving your default requests. So we have a number of those cases today. The other thing I want to emphasize too is on this case today, we have Ms. Bankhead. You all may want to take the opportunity to talk about this matter, see if you can reach some sort of agreement as was done with the last case.
I don't know what this is.
Okay, well, I will go through that with you. One moment, ma'am. So
Okay.
that's what we have. So let me look at this. So, ma'am, what has happened is you are being sued by LVNV Funding. They're the plaintiff. They're saying that you entered into a contract with Credit One Bank. And they are saying that there was an account open on March 30th, 2014. And there's no agreement here. I don't have one. They didn't include it. They just say that you defaulted with that contract. They're also requesting that there was an assignment. I don't have any paperwork to that effect. So there is really, at this point, no need for me and no good cause for me to grant the motion for reinstatement because the complaint is not sufficient. So you all may want to talk. Okay.
Yes, Your Honor.
All right, I'll put you in a breakout room. So, Ms. Bankhead,
Yes.
You heard what the allegations are, but the case was dismissed because there was no activity on this matter. But that does not mean that the law firm can't bring this up again or whatever. If you want to, you can speak with the other party. You do not have to, okay? That's up to you.
Okay.
Are you amenable to that, ma'am?
Yes.
Okay. All right, then. I'm going to put you in a breakout room, both of you. We're going to take a short recess. You're going to go to breakout room number 1.
Thank you, Your Honor.
Thank you.
Join breakout
Have
room.
yeah, you should get an invitation, go there, and then come back when you're done. Okie dokie. All right, short recess. Okay. What happened to the guy? What happened? Okay, well, he was there. All right, I see Mr. Sparks is back.
I don't know where Miss Bankhead went. I went back in the,
Yeah, she's not in. She'll call back.
okay. We did reach an agreement, so I'll wait for her.
Well, in the meantime, I have a couple of other cases of yours because she got disconnected before and she called back. So
Okay.
I suspect that she'll call back again. So we got a couple of other matters of yours. Let me try to call those. We don't have any other defendants at this time. So let me start with LVMV Funding LLC versus, oh, that is Ms. Bankhead's case. Okay. Leave that over to the side. LVMV Funding LLC versus James Mariner, 2116-3913. Parties, place your appearance on the record.
Good morning, Your Honor. Keith Sparks here on behalf of the plaintiff P77485.
All right, the defendant has not signed in. We got that earlier. In this particular case, the summons and complaint was filed 8/17/21. There was personal service 9/5/21, a notice of intent to dismiss 12/17/21, and a dismissal for lack of progress, administrative dismissal 1/31/22, followed up with a motion for reinstatement by the plaintiff on 3/7. The motion to reinstate the case indicates that the default request was mailed on or around November 10th, 2021. We have no record of that. It's not on the register of actions. The plaintiff did submit a copy of a proof of service of the taxation of costs. And there's also a letter dated February 7th of 2022. But that would have been after the dismissal was given. The dismissal was 1/31. So
I believe the February 7th letter is for the motion to reinstate, Your Honor.
it is. Thank you.
Yep.
Okay. So I am not seeing anything for the last cases. The letter was to support the plaintiff's position that, we sent a letter in requesting a default. So I thought this was one. I don't see a letter here at all, just the requesting a default. I don't see anything like that in this file.
That's correct, Your Honor. I believe, sorry, one second, let me look at. So we send the bill of costs and default judgment out at the same time. That's, we serve the taxation of costs on the defendant. And those should have been filed with the court at the same time. Similar to the other cases, I think there was one or two before I came on when you were speaking with Craig. Basically, there was some mix-up, I'm assuming on our end, with the mailing of the default, as well as apparently the only reason that we found out about these hearings was that we were checking the dockets to see when the default had been entered, and found out that the cases had been dismissed, and that's why we filed motions to reinstate on these, I believe, 6 cases.
Yeah, when I was talking with counsel before, I'm like, we have 2 issues here that need to be addressed. One is that for some reason you all are not receiving the notices of intent to dismiss and the dismissals, the administrative dismissals. Our administration is saying they've sent it out to you. So I don't know what's going on your end though. And the other thing is that we are not in receipt of your request for default on all of these. So
Yes, I mean,
even
sorry.
after the dismissal and the notice, we have not received anything that would indicate that a default request was sent to the court. So
Sorry.
No, I was going to say, so this is we have two issues here, and they need to be resolved as soon as possible. Or you're going to be spending a lot more time here in court over some technicalities but matters that still need to be adhered to. So you're an officer of the court. I'm going to take your word for it that you did try to submit something, but I was just indicating here, at least with the other cases, there was a letter to the court saying, hey, here's our request for a default judgment. I don't have that here. All I have is the proof of service for the taxation of costs and your word that usually that goes out with the request for a default.
Yes, Your Honor. And I mean, from time to time, you'll get a mix up in the mail. I do agree that it's unusual that, a larger number of cases, these 6 cases, where there's a miscommunication or a kind of missed filings and things like that. From time to time, it's kind of explainable. In a one-off situation like that, with this being, we do quite a bit of filing.
Right.
So 6 cases is not small.
Yeah.
But it's not unheard of. So I mean, I don't know what happened with this batch. They seem to probably have gone out around the same time. I think the first one was October 14th, and I think this one was October 10th is what we put in the filing.
Okay. Well, I'm going to grant your motion for reinstatement. I'm also going to give you a default. Just so the case can move forward. It is not just sitting around. And it is up to you to request that motion for a default judgment. But I'm telling you, first I look at your cases procedurally to see if you follow through with sending in the notice of default to the defendant and then sending that to the court along with the proof of service that you sent it to the defendant. But not only that, then I look to your actual complaint to see if it's sufficient for me to determine damages with reasonable certainty. If I don't have both of those, there is no default judgment, just to let you know. But I will grant the default today, the default alone, and reinstate your case, okay?
Thank you, Your Honor. And when did that change? I know that that's a newer procedure for the 36th District Court, which sending the notice of default to the defendant, waiting, and then filing it with the court. That was around the turn of the year. So I think these were probably filed before that time period or when that change was instituted. But obviously with the default being reserved or received today, we'll go by the new procedure.
Yeah, and actually the court rule had been changed a couple of years before we did it. It's been on the books for a while.
Right, I know, but it's been enforced now for 36 for the last 3-4 months. So.
Exactly, we tried to initiate it the end of the year to get everybody ready, because I know everybody's used to doing it a certain way, especially if you do bulk mailings, bulk work here. So yeah, that's what we're doing now. So and this court looks a little bit closer at the complaints now too. So for your, like I say, your request for your damages. So that's taken care of. And then I have one last matter. And it looks like that is LVMV Funding LLC versus Lavita J. Williams, 21161170. Please place your appearances on the record.
Keith Sparks here on behalf of the plaintiff P77485.
All right. Lavita J. Williams, I don't believe she's checked in today. Officer, would that be correct?
That's correct, Your Honor.
All right, very good. So in this particular matter as well, we have summons and complaint filed 7/12/2021. There's personal service 7/31/21. On 11/24/21, notice of intent to dismiss the case, and then on 1/13/22, the dismissal for lack of progress was entered administratively. It was followed with a motion to reinstate the case, which was sent to this court, me, 2/25/22. And in this particular matter, the motion for reinstatement has to have good cause. Going over this with the other matters, I just want to make a record for this because the situation appears to be the same, where the plaintiff is indicating they did not get notice of the intent to dismiss well, they didn't get notice of the notice of intent to dismiss, and neither did they receive the actual dismissal for lack of progress. The court, on the other hand, did not receive the default request at all, as the motion would indicate, on October 15th. And in this particular matter, court has the taxation of costs, a proof of service of that. That date is October 15. And there's also the letter August 30th indicating that dear clerk is to the court indicating that they are requesting a default for the same reasons as previous cases that we have discussed today. I'm going to grant your motion to reinstate. Defendant is not here as well, so we're going to enter a default because there was personal service. You're gonna need that military or non-military affidavit and facts to support. So enter default. And that should be that for this case. Now let me get back to 803, which was Ms. Bankhead's matter. You're an officer of the court. This is again LV Envy Funding LLC versus Eleanor Bankhead, 211-63803. I've put the parties in a breakout room, and Ms. Bankhead has not made it back. And this is not the first time she got disconnected from the Zoom room, and it took her a while to get back. But counsel, again, you're an officer of the court, so I'm going to have you tell me what happened, and we can see where we can move forward from there.
The parties discussed the account, also the service, and we worked out an agreement. I believe the complaint was for, sorry, I'm jumping between.
That's okay.
Different files, 1 second. The balance of the amount paid for in the complaint was $1,261.30. The parties had reached an agreement whereby we would settle for the amount of $950 to be paid at $50 a month. I also indicated to Ms. Bankhead that I would send her a conditional dismissal instead of a consent judgment so that there wouldn't be a judgment attached. The one thing we did not discuss, and I realized that I was sitting here waiting here, was a start date for that first payment. And so I will prepare that, and I'll probably set the first payment date out 45 days and just see if she's able to sign it and return it. Let me see if we have a phone number for her. I'll also attempt to call her once this hearing's over. I've got 2 possible numbers for her to clarify when she wants the settlement plan to start.
Okay.
Yeah, so the parties reached an agreement for a settlement amount with a conditional dismissal.
Well, I gave, there was another settlement today, and I gave the date of 5/5 as a control date.
Okay.
I'm hoping that gives you the time to draft up the agreement, send it out. She sends it back to you and all that. And if that is the case, of course, if I sign off on it, you don't have to come back on that day, but I don't want the case to fall through cracks, particularly since, given the circumstances of the case. Okay.
Understandable. That was May 5th at which time? 10:30 again?
9:30. 9:30.
9:30. Okay.
Yes. I do believe so. You'll get something in, you'll get something written, okay?
Okay. I'll call her as soon as we're done here and try to get that out as soon as possible.
All right, well, thank you very much for your time today, sir. I appreciate it. You have a good day.
Thank you. You as well, Your Honor.
Okay, bye-bye.